Well, I think we're ready to get started, and just on behalf of Ethan and I, we are both so excited for you guys to be here today and sort of taking the next steps on thinking about getting your estate plan done. I'm going to hand it off to Ethan, and we'll just kind of jump right in.
Hello everyone, thank you for coming. I really appreciate you taking the time. If you haven't, we have burritos in the back. My name is Ethan Cortez. I'm a realtor with Keller Williams, and I wanted to put this presentation together because I feel like everybody should have a will or trust. If you have kids, if you own a business, if you own real estate, if you have rental properties, probably should have an estate plan and a will and trust set up. Something a little personal of why this hits home for me is that I had grandparents that didn't have a will and trust set up. They lived in the same house for over 50 years, and when they passed, that property didn't go through the proper channels to allow it to stay within our family. So my family was faced with a situation where they had to sell quickly because the bank was going to repossess the house if they didn't sell it. And so they sold it to a fix and flipper, which good if you're the investor that you made a killer deal, but bad for the family because you ended up only selling it for about 70 cents on the dollar. There was probably about $100,000 in equity left on the table because they had to sell quickly. So that's why I feel like in that situation a will would have definitely saved some of the family heartache. A little bit about myself. I'm from Wisconsin. I come from the world, before I was a realtor, I come from the world of like asbestos and mold remediation. So for 5 years I was an inspector, and now I have to kind of bring that experience to my real estate business. For people that are looking to buy a house, I can give some of that information to them from my experience in that time. And I also help my clients move if they purchase or sell a house, help them move in and help them move out. Thank you for coming, and without further ado, here's Moorea Diamond to talk about estate planning.
Hi guys, Ethan, do you remember any of the slides? My name is Moorea Diamond. As Ethan mentioned, I'm a local estate planning attorney here. My firm is based out of Westminster. We've been in business about 3 years. I'm a Colorado native, so I was born and raised in Springs. I came up here for undergrad at CU, and I went to law school at EU. I just can't get enough of it. So my practice primarily is focused on estate planning, but I can also assist with criminal record sealing, business formation documents, talking about getting LLCs started up, and also different deeds I can draft and stuff for you guys. Why is estate planning important to me? Well, I think it's the same reason it's important to all of you guys. When I pass or something happens to me, I want to make sure my loved ones are protected and that they're not left with sort of a headache or a mess or a situation where our assets aren't being passed down in a beneficial way, kind of like what Ethan was talking about. So who should have an estate plan? Everyone should have an estate plan. And I think it's this really outdated idea that I see oftentimes when people come to me, they're saying, oh, well, I'm retired, I think it's time to take care of it. And absolutely, take care of it. But also too, it's for younger families too. I really think that you should have an estate plan if you have a business, you own a home, any home, period. You have minor children, you have children who maybe need some extra assistance or disabled in their lifetime. If you have houses in multiple states, your estate is taxable. There's a number of reasons why somebody wants to estate plan. So, it's a new year. I'm so excited that you guys are kind of taking the bull by the horns, check that big thing off the list, and start thinking about those first steps for getting your estate plan done. Okay, so we're talking about why do people create estate plans? Well, we're talking about protecting your assets in your businesses. We're talking about protecting your spouse, your children, your family, avoiding certain tax implications with estate tax. We're talking about avoiding probate, which can be really, really expensive and a mess and a headache for any of those who've been through it. We're talking about preventing disagreements of surviving families. Oftentimes, families look a lot different than they did 40, 50 years ago. We've blended families, we've stepchildren, we've adopted children. We want to keep our families together after we're passed and kind of create a smooth plan that we can all talk about in our lifetimes, right? To kind of keep things going. We're also talking about those young children and really what an estate plan does, whether we're talking about a will or a trust. We can put designations for what happens to our children after we pass. So what happens if you don't have a will or a trust and you pass away in the state of Colorado? Well, it's this big word called intestate inheritance or succession. So that's really legally jargony. What does that actually mean? Well, it means that the court is going to determine what happens to your assets. The court will determine what happens to your children. And you're going to go to probate, and a judge is going to say, hey, using like basically a procedure that they do for hundreds of cases, and they're going to process your family through. And we're talking about it's going to be expensive. It's going to be long. In a previous life, the type of attorney I was a criminal defense attorney. I was in court 3-4 times a week, and I can really see how working closely with judges, they're really about moving their docket through, and your family can quickly become just a case number and stuck in the court system. And it can take months, if not years, to close probate. And the biggest issue is that while probate's ongoing, all those assets are going to be frozen, meaning your family could be locked out of the ability to sell their home, bank accounts. This is huge, and so that's why you really want to make sure you don't fall into this intestate inheritance, and you take that control back into your own hands and not let it, be determined by a judge after the fact. Okay, so probate, what is it and how can we avoid it, right? That's the big thing. So like we were talking about, probate is a court supervised process where a judge will determine who has title or ownership over a person's assets once they pass. And we'll distribute that, and we'll also hold the estate open for a certain amount of time so that creditors can come in and get their take, right? There's kind of two camps of probate. Informal, which is where most people fall into if they have a will and plan correctly, or informal, and we're talking about kind of like the happy, smiley, as quick as possible type of situation, or a situation where your family is going to be spending tens of thousands of dollars after you pass to kind of get those assets out of your estate. There's also a small estate process that's in that informal camp for estates less than $70,000. And that's a different process where if you come, you need help, we can talk about where you kind of fall into play. But again, formal is the one where we really want to avoid it. If you die in that intestate inheritance without a plan put in place, you can bet your bottom dollar you're going to formal probate. Again, too, you have disagreements with family members, things like that. We're talking about contested probate, formal probate, and that's nasty kind of situation. This is a common misconception. Every will go through probate, okay? The only way to fully avoid probate is with a trust. And so basically, again, the idea being that when you have that will, that foundational document, it'll be a much simpler process where your personal representative is going into probate court. They're filing the will and death certificate. They're getting that process started, that time period started, and then things should close out and be dispersed, like they're put in a will, if a will is drafted right, okay? So let's talk about what is a will. Well, a will is a legal document that, again, it appoints this person, this personal representative to administer your estate and outlines who gets what person gets which assets. It also designates the beneficiaries. Who are your heirs? Who are your children, your grandchildren, those types of things. It also could include a designation of guardianship if you have minor children as well. The big thing about a will is that it avoids intestate succession. So that way, at least your wishes are respected as you go through the probate process, and it's the court's process to respect those. A valid will has a few requirements in the state of Colorado, and every will must meet these. Basically, it must be done by a person who's 18 years old. They must have capacity, and that really comes into play sometimes. I have clients who come and their parents are 90 years old, right, without a will, and they're struggling with dementia. Well, maybe they don't have capacity and it's too late. That's why don't sit on the estate plan, don't sleep on the estate plan. Get it done now while you have capacity to do so. And it will basically, that's the main thing of why if somebody does have a will and it goes through that formal probate process and it's contested or fought, it's because there's a question of, oh, well, mom was 95 when she redid the will. Did she actually have capacity to do so? The will must always be in writing. This can be handwritten or typed. It must be signed by you, the testator, the person making the will. And then it also must be signed by 2 non-beneficiary witnesses, meaning people that aren't related to you, people that aren't going to get something after you pass. And then again, they must be notarized. All wills are eventually, like we talked about, filed through probate court, but most will go through that either that small estate process or again that informal process where it shouldn't be too many headaches, muss or fuss. Let's talk about the risk of holographic wills and using online programs like Trust or Will or LegalZoom, right? So, like I talked about, wills can be handwritten in the state of Colorado. You could theoretically write your own will, right? Just all it needs to be is in your handwriting, sign it, and go. But what could be the issue is that may not be a valid will. And what it's gonna do is 9 times out of 10, that holographic will is gonna open up that can of worms, that formal probate process, right? Is it actually your handwriting? How does the court know that it's you, right? And so again, you think, oh, I'm gonna save my family a couple grand, and I'm just gonna do it myself. Well, no, they're gonna be spending $10,000, $20,000, $30,000 in probate court, right? The other issue too, with programs like Trust or Will or LegalZoom, they're running about, I think, $800 a pop. Again, a few $100s cheaper than what an estate planning attorney might charge, but again, 9 times out of 10, they're coming up in court because they're missing these elements, and they're actually not going to be a valid will. And so again, even though you spent that money, you think it's right, if you go on Reddit or look at the reviews of those programs, 9 times out of 10, their family, back end is going to be in that formal probate process, spending all of that money with that massive headache. So again, it's always so important. Come to the expert, right? Come to someone who knows what they're doing. When you work with an attorney, you can have that experience you trust. You can answer those questions, and you really know what is actually going in your will and your estate planning documents. Okay, so a trust. This is kind of the new age of estate planning, the new frontier. And I'm really excited about trusts in my practice because they're a container for your assets. This is the one way when you come to me, I can guarantee you your family is not going to be dealing with probate once you pass. And this is why. Again, the container for your assets. During your lifetime, you come to me, we make what's called a revocable living trust. Hi, come join us, no worries. So you come to me and I create for you what's called a revocable living trust. That's a lot of, again, legal jargony words. What does that mean? Well, revocable means being able to be changed, right? So during your lifetime, it will be able to be changed. Basically, in the process of a trustee, you appoint a trustee to manage the assets, and that person has a fiduciary duty. During your lifetime, you're the trustee. You manage your assets. You can put houses in your trust, cars in your trust, assign business interests to your trust, and change that as you go. You can also put certain terms and conditions, and we can edit those, again, during your lifetime, because it's in that revocable camp, it's able to be changed. Well, once somebody dies, or if you're a couple, once you and your spouse die, right, then that trust goes from revocable to irrevocable. It cannot be changed. And so what that means is your appointed trustee will basically have to follow those terms in those trusts. Will have that fiduciary duty to manage the assets in the trust for your beneficiaries. And if they need to change something, they will have to, again, go to the court. It's not as intense as formal probate. It's usually just filing forms and letting the court know, hey, we're just making these changes to a trust. Again, some of the benefits of why I'm really excited about trusts in my practice is that they're private. They don't need to be filed with the court. A will, right? And that'll be a public document. Usually wills are kind of vague. I don't know if you guys have seen one before, but they're usually not super specific. And again, that's wise because they're usually public documents and they're court records, right? Trusts are going to be the fastest way to get your assets to your beneficiaries after you pass. And it's really, really, really important to do so, especially if you have businesses, right? So oftentimes I see people who have especially rental properties out here in Colorado, and they can get frozen out of those rental properties. But if they're in a trust, it'll just slide right through. Again, bank accounts, retirement accounts, life insurance policies, everything can kind of be nominated to this container, right? And then the beneficiaries will have immediate access to the said container. Let's talk about minor children, disabled children. I really, caution people, hey, when you come to my firm, you work with me, you've got minor children, disabled children, I always, say a trust is the gold standard. Why? Because you can put those terms and conditions on a trust. Like, I don't want my kids to have full control until they're 25, or I want them to use X amount of money for their education, right? God forbid you're 16 years old, you inherit a house, all of this money, you can kind of lay out those conditions that the trustee can work with the beneficiary and manage, right? You don't like your child's spouse, right? Or they get divorced. Those things, you can look ahead, plan for it in the trust. Again, trust will have a document that's called a pour-over will. That will be filed informally with the probate court after you die, but that pour-over will basically just says anything that isn't put inside of the container is directed to flow to the container of the trust after you die. And it's a super simple document. And again, what we're talking about here is that it's avoiding probate. Why this is the new age of estate planning is that beforehand, a lot of older people in this practice of law were kind of just, it's a little bit pie in the sky, you don't want to spend the extra money now. But really the issue is that those people who were writing the estate plans with just the basic will were cashing in, because once people passed, their families would come back to them, and then they would get the probate fees hourly, $10,000 to $20,000 an hour. So I truly believe I'm the type of attorney that I'm all about flat fee, transparency, and that's why I don't really want your family to come back to me and give me more money after you die. I want it to work, and I want you to have that peace of mind that your family's protected. Okay, so benefits of putting real estate in the trust. This is the most important thing about trust that I feel like has the best benefits. We're talking about when you have a rental property, right? You carry this risk of, while you have this property, that somebody could slip and fall outside on the ice and sue you, right? And come to your personal assets. A way to protect that is by putting those rental properties, each rental property, in a little LLC. And that will basically shield you from your personal assets being able to be accessed if worst comes to worst in a situation where you're sued, right? The cool thing about trusts is it's that big container. It can hold those LLCs with the rental properties really well. In that container, bank accounts, it all really kind of makes sense and can be this kind of cohesive thing for regular people if you're interested in rental properties. Again, simplifying the probate process if you own properties in multiple states. Luckily, probate, especially informal probate in Colorado, is very simple. And that's because we have a unified probate code. Some states don't, and it can be crazy. We're talking about New York, California, Florida. Those states actually require you to pay attorney's fees to the other party, and it can get even wilder. But the cool thing about the trust is, let's say mom and dad have a vacation property in Florida, they have their regular house here in Colorado. They won't necessarily have to open up probate in Florida or Colorado because that property, that real estate's in the trust, and it's not technically considered an asset that passes after they die, right? because it doesn't really go with them, it stays in that container. We're talking about avoiding certain tax implications. So just like how, we're talking about, how things will come with you or be considered assets in terms of when you have to pass away and open probate and all these things, it's the same thing for taxes. And so if it's in the trust, it may not trigger certain tax events versus if it was just owned by you personally when you passed away. Something that I do see quite a lot with property, real estate, especially here in Colorado, everybody's like, I know how to do this. I'm going to avoid putting my house in probate. I'm going to set my kids up just right, and I'm going to quit claim deed them the house for $1 when I live. And then that way it's not part of my estate because I'm doing it while I live. Well, there's huge issues. The biggest one is that your loved one is going to be subject to step-up tax. So what do we know about property values here in Colorado in the last 10, 20, 30 years? They've doubled, right? Tripled in some cases. So your kid isn't going to be paying that step-up tax for when they get that property through that quitclaim deed. When you sell it to them during your lifetime, they're going to be subject to the tax for the actual value it is now. So we're talking about mom and dad's house was $200,000 in 1990. Now it's 1.2. Well, you're paying taxes on the $1.2 million property. Same for land, same for ranches, all these things. So that's a huge issue I see with a lot of people where they think, oh, I'm gonna save $1, I'm gonna do all this, it's gonna be great. And then you end up kind of making, again, a bit of a mess for your kids, where if you just, invested the time, worked with a professional, got a trust set up, it would have been a smooth, seamless process. Do you have any questions?
No.
Awesome, okay.
I have a question.
Yes.
So you said like if the house is at $299 and it went up to 1.2, the kids has to pay the tax on 1.2.
It's
right?
possible, yeah.
But isn't that like don't you have to deduct the price that the mom and dad paid for that?
And again, I'm not a CPA, so I don't specifically know the answer, but I do know that you'd be subject to a step-up tax at the actual valued rate. It wouldn't be you wouldn't be taxed at like the $1 that you actually sold the property for. And so I think that's the issue, is that people are expecting, oh, well, I'm just gonna get the rate that mom and dad had, which is like maybe 10,000 or something like that. And then all of a sudden it could be way, way, way past that, right? So, any other questions before we move on? Power of attorney documents. I actually think these are the most critical and crucial documents you can have. When we're talking about estate planning, we're really talking about taking care of our loved ones, right? Because a trust or a will may not benefit us. Well, actually, trusts do benefit you in your lifetime, but a will may not benefit us in our lifetime, right? Like that's for our family. It's the same thing with life insurance policies. People are like, well, that's not for me, that's for my family. But the power of attorney is for you, and it's for your family, and it is going to be necessary in your lifetime while you're living. So basically what these documents do, there's two types. There's a medical document and a durable document, which handles finances. And you're gonna appoint an agent to act on your behalf to make those medical or financial decisions. And then you're gonna basically put in a successor agent. In estate planning, we always put successors to everything, because you never know. You never know. We're playing checkers, God's playing chess, right? So that's kind of how that will work. And again, with the durable financial power of attorney, what this will do for you is that if you were incapacitated, let's say you're in a car accident, you're in a coma, they're going to be able to pay your bills, pay your rent, access your bank accounts, potentially talk to your employers. A medical power of attorney will be able to work with your doctors to make decisions for you. And oftentimes hospitals will have a very similar type of medical power of attorney document, but I really do think that when you come to an estate planner, the ones you get from the hospitals, and I've seen them, they're just kind of basic. It's just a form, and you just sign your name, and you put someone else's name on it. The medical power of attorney can really be tailored to you and your needs. And we can talk about too, when do these take effect? What does incapacity mean to you, right? So the other thing too is what happens if you're in a situation where you don't have these set up. Well, unfortunately, I had somebody call a few weeks ago. Their friend was in hospice. Their entire family was lived in Brazil or out of the country. And basically, yeah, she was going to be evicted because she did not have access to pay her bills. They could not communicate about medical decisions, and so doctors are making decisions for her because her family was not there and they would not talk to the friends. And again, at that point, all I could do for him is, she's in a coma. She doesn't have capacity to make these documents, right? All I can do at that point is say, well, I can refer you to a different attorney who does conservatorships, right? And then again, we're going back to probate court, the place we don't want to be, right? And we're talking about that process of you're in a judge's docket, your case number, and that could go on for months and months and months. Again, tens of thousands of dollars in legal fees, when we all know when somebody's in hospice, they're in a coma, we don't got that kind of time, right? So again, it could save you massive headaches, and that's why I feel like these documents are some of the most crucial to have.
What is a conservatorship, Lauren?
A conservatorship is a situation where the judge or probate judge will set up and appoint somebody to do those things, to act as your agent for medical decisions, for basically financial decisions. And that could take some time if, for example, you have multiple kids, right? You're divorced, and I think it can get kind of messy. And sometimes people can take advantage of conservatorships, right? I think we all know from the news what happened to Miss Britney Spears, right? So it's one of those situations where it's just like if you died in intestate succession, right? You don't get to make those choices. You don't get to have your rights or your wishes respected. And it's the judge and whoever's like biologically closest to you or can show up to court to help make those decisions. And so I think that's why it's one of those big, scary, no land situations. So any more questions about power of attorney documents? Okay. So let's talk about some other estate planning documents that are foundational, are included in my packages, and that I think are absolutely necessary. We're talking about living wills. This is a little bit different from the medical power of attorney, but they kind of go hand in hand. This will basically lay out what type of long-term care management you would prefer. Do you want artificial nutrition? Do you want to be on machines for a certain period of time? When would you like that artificial nutrition or life-extending treatment to end? How would you like it to end? And so that is also a really important document to have as well. I think 20 years ago, there's a very famous case out of California where it was a wife who'd gotten into a serious car accident. She was brain dead, and her husband and her parents were duking out in probate court for years while she was hooked up to machines to be able to say, and have her rights and wishes respected. Sometimes we think, I'm married. My parents, I have a really simple family system. This is gonna go exactly how I want. And you know what? Life has other plans, right? So that's why the living will is such a critical document. HIPAA releases. That language has always been included to a certain degree in your medical power of attorney, but health insurance companies, they are such a peach and a joy to work with that they actually now require a separate release apart from your medical power of attorney document to talk to you at all, even if that person is nominated as your medical power of attorney agent. And again, super helpful in your lifetime. You're trying to call and figure out what claims of moms are covered. Can I get mom to this hospice facility? It's critical. The last document is actually a little bit different. It's not a legally binding document. We're not notarizing it. It's a guideline, basically for how you would like your final remains to be deposited for. I can't tell you how many times, sitting at that funeral home after my grandparents passed, my parents were in shambles, my aunts and uncles were so stressed out and drained, and they have to make all of these costly, time-consuming decisions about, okay, well, what would mom want to play at the funeral? How many people, what casket, for example, we lost a grave site plot. That was a fun little thing to figure out. And so that will be kind of that guideline of like, okay, here's what I want. I want it to be in this religious, form, fashion. I want to be cremated. And mom, she has this plot here. I have this plot here. Here are the receipts. and it can just be with your estate plan all together, nice and organized. And again, make it easy for your family members once they're grieving, right, to kind of have it all together. Okay, fun part. And again, I'm not a CPA. I do not have my master's in tax. Maybe one day. I don't really want to go back to school for it, but it is so critical and important, and I'm really excited to tell you about kind of the basics. So how it works is there is an amount that's been set by the federal government that basically says if your estate is valued at this amount, it will be over this amount, it will be considered taxable. And what does that mean? Well, that means you're going to be subject to that estate tax we've all heard about, right? It's like 40%. So most of us don't fall into this camp, but I've been surprised, right? Especially out here with Colorado, sometimes our real estate will be valued at that, your retirement accounts, it goes into everything. So right now we're looking at values of $13.99 million for an individual, $27.1 million for couples. And then this was actually set to sunset this year and go back to a 2018 level of $5 million adjusted for inflation. We in the estate planning world think that that's going to be about $8 million. Due to the incoming incoming administration, I suspect that those numbers of 13.99 and 27.1 will stick, and most of us will not be above our basic exclusion amount. But again, we never know, right? And it will shock you how many people really are, once we're talking about retirement accounts, life insurance policies, houses, really can get to that $5 million adjusted for inflation number really quickly. So let's talk about estate tax at the state level. So as we live in Colorado, we're Colorado citizens, we do not have an estate tax at the state level, but other states do. And so if you have property, ties, businesses to other states, you need to talk to your friendly CPA, financial advisor, tax planning person to make sure that you're setting yourself up to sort of maximize those benefits. And in that situation, we're probably talking about a trust. Gift tax. So this kind of goes hand in hand with your basic exclusionary amount. You can give anybody per year $19,000 an individual. And that includes your kids too, right? Sometimes people think, well, if it's kids, I give them everything during my lifetime. Well, no. What will happen is basically that $19,000 per individual, let's say mom and dad each give the kid $19,000, we're talking about $36,000 in a year. Anything above that amount will be subtracted from your basic exclusion amount because that is over your entire lifetime. So basically, let's say we give mom and dad give the kid $100,000. Well, $36,000 is excluded, but then the rest will be deducted from that basic exclusionary amount. And again, it's just something to note. It will also trigger a requirement to file an informational form with the IRS. Doesn't mean you have to pay taxes on it now, but again, IRS. So gift tax, another way to avoid some of these basically taxable events is through the trust. And again, if you have any specific questions, I'm always happy to consult with your CPAs, with your financial advisors, work as a team to make sure that your estate plan is working for you. Let's talk about what packages look like, right? I'm talking about, you come to me, you say, Miss Diamond, I loved your presentation, or it was all right, but I really need help. What's the first place to start? Well, I have two packages that are kind of my main kind of way of thinking, but we can always adjust and add on whatever makes sense for you and your family. A will package includes that will, that medical power of attorney, that financial power of attorney, your living will, your HIPAA release, and your declaration of disposition of final remains. Trust package, we're talking about our trust document, our pour over will, our medical power of attorney, our financial power of attorney, our living will, our HIPAA release, our declaration of final remains. Vehicle beneficiaries, right? Because we're talking about putting the vehicles in the trust, right? We're talking about property transfer deeds, putting the property in the trust, funding the trust. And so that's kind of how that works. These I priced out at a flat rate. That's what it is. I offer discounts when you do it with a couple, and yeah, we'll talk about kind of more about what the process looks like with me. So kind of the first step of when somebody calls me at my firm, I answer the phone, I answer my emails. I love my paralegal, but I really feel like it's important for me to connect with clients and to really understand what's going on. We do a consultation call, we talk through the packages, what's included, pricing, timelines, times frames, general goals. It's about a 15-20 minute call depending on what time you have. And then we're talking about a comprehensive intake form that I have. It's sort of an online form. It's super fun to fill out. You can save it, come back to it. But really what it does is it gives me a full picture of what do you actually have going on in your estate. You can upload property deeds, we can upload beneficiary documents, make sure those are all in place. And then we go to a design conference that's 2 hours that I block off just for you. I could come to you, we could do it over Zoom. I really want to make this a comfortable experience. I know I'm in a little suit today, but that's just for show. Like, I really don't want to be this old-timey attorney thinking that I'm not accessible. I want you to be comfortable. So we're going to go through that design conference. 2 hours is a lot of time, but again, I really want to know who's in your family. What do you think of them? What do you want? Where do you see yourself in 5 years? Do you think you guys are moving? What are your goals for your family? And really get to the nitty-gritty of everything, right? And then once I have an idea based off of that conference about what you would like to do moving forward, what type of package you would like to pursue, what deeds you need, then I go and draft. It usually takes about 4 to 6 weeks, but I can certainly expedite that process if needed and get that out to you quicker. We'll have another meeting to review the drafts together, go over it, make sure everything is to your liking, that you feel comfortable, that you understand how your documents will work, right? Because this is for you. Then we'll go to a signing ceremony. That's that official process, right? Where we're gonna have my paralegal, my notary, and we're all gonna get these documents done together. And then after the signing ceremony, I'll take those original copies, scan them, put the originals in a sweet little binder, put a flash drive with the digital copies, and then I'll give them to you. I so recommend getting a fire safe, putting them somewhere really safe. But the good news is Colorado's now starting to come into the future and saying, well, a copy may work and it may not trigger formal probate, right? So the cool thing about me is that I'm obviously a younger person. I could be in business for 20, 30 years, and I want you to know that you can always come back to me if you lose a document, something's going on. The other thing too, again, I'm answering my own phone, I'm answering my own email, and phone calls and emails are not something that I'm gonna charge you like $37 if you have a question. I never want to be that attorney where people are pausing and being like, well, I wanna talk to her, but I can't. I want you to feel completely comfortable throughout this process, making sure you understand what's going on. Let's talk about it. So the numbers are that 70% of Americans do not have an estate plan. Crazy, right? 30% that do, I can guarantee you they haven't updated it. And so what does that look like? Well, sometimes I'll volunteer and I'll help out. I had a little lady who lived in Arizona, and her will, she's like, well, it's a valid will, it's from Arizona. I'm like, well, no, you gotta redo it in Colorado, right? We're talking about you move, you divorce, your spouse dies, you get remarried, you have another kid, you have more grandkids, you buy more property, especially if you have that trust. Come and see me, come back to me. Like I said, I'll be here for you. Diamond Law LLC will be here for you. And we're, there to kind of tweak things as we go, keep those updates going, and know that you have a place to come. A lot of estate planning attorneys in the local area and in Denver, I'm noticing, are starting to retire, right? It's not necessarily the sexiest, fastest form of law. We're not all going to law school to be estate planners. So that is a benefit too, that I'll be here for a while, and I'm starting to take referrals from those firms that are starting to retire. Alrighty, well, I just want to say from the bottom of my heart, I really appreciate you guys coming here. I can really tell that you guys are dedicated about protecting your loved ones and really making plans, and I think you guys should all give yourself a big pat on the back, because getting that new year off right and checking something huge off your list And yeah, I'm just gonna spend the rest of the time answering questions. Again, we got burritos, and